Right, we're back live with you tonight. Let's get the reply now from the Road Accident Fund CEO, Collin Letsoalo, on the conversation we just had with the National Association of Democratic Lawyers about the state of the fund. Good to have you, and thank you very much for your time and coming on tonight here on In Focus. Let's just come with a few things that we've been hearing so far. I mean, the fund has been making all the wrong kind of noises, if one would like to say. Scopa says it's a national disaster. In fact, when they came and visited your Joburg branch, they said that thing is a car wreck. There are boxes of paper everywhere. Staff morale is down. Staff is telling that they are living in an environment of intimidation, and so on and so forth. You've got a judge who's concerned, for example, about the fund's ability to function. You've been hit with cost orders and so on and so forth. One looks at that and says, is this ship holding, or is it falling apart, or is it crumbling? Are you in a crisis?
Good evening. Good evening to the viewers. I think, let me start by saying people suffer from what is called the Mandela effect. It's called confabulations, where one has got a problem of really getting wrong about what the events are. And I think that's what is happening here. And I think these distortions are problematic. I think here is someone who tells you that it must take 120 days and it used to take 120 days, and then says, well, you have waited for 3 years. What is this 3 years? Now you can tell there are conflicting statements in what she was saying. And very clearly the bitter pill to swallow is the part where they are telling you about the requirements of a CEO. Is it not ironic that lawyers are asking that the CEO of RAF must be a lawyer? Why didn't you ask them, why didn't they apply? Because I contested with lawyers for this position. And when I was successful as a candidate, they took the matter to court. Right. They lost. Right.
I'm going to come to the lawyers in a moment, but I just want you to talk to me about the oversight that comes to your offices, and they say things are falling apart.
Let's deal with this once and for all. Yeah. So when you look at an organization, Tabo, you look at the objective facts. And what must tell you is that your annual performance plan, which is an APP, would have what is known as the predetermined objectives. So we have predetermined objectives. When we arrived in the Road Accident Fund, the fund was performing at 56%. And the fund was having deficits, big deficits. And when we started this work, we increased the performance to 78% in the next year, which is a 22% increase. And then the next year it was 84%. And I'm well saying this year is going to be above 90. We're just finalizing our audit with the Auditor General. And once it's audited, we'll come to the public and tell them. So that is the assessment that we do. So quarterly we go to the portfolio committee. We tell them about the predetermined objectives, and we tell them how far we are from a budgetary point of view from all those things. So those things have been done. So there is no truth to the fact that there is anything that is collapsing. Now, Tabo, when you find stuff in boxes, what's wrong with papers that are in boxes? Because I don't understand this thing. I mean, people arrive and they say, well, we found files in boxes. No one is telling you, I went to the Road Accident Fund looking for my file and I could not find it. Because it's there in a box. And that's where we store stuff, and that's generally what happens in an organization. So, and this is created by Section 54.
So you're saying Scopa was making a storm in a teacup, basically. It was,
absolutely. It's a political farce. It's a farce that is trying to create a situation that says this sixth administration came and collapsed the Road Accident Fund. The Road Accident Fund has been bankrupt from 1981. Now, you sit there, you know these facts. Now, let me quote for you a judgment that was done by Judge Bertelsmann on the 8th of May 2015, right?
Yes.
About it's Ketsekele versus the Road Accident Fund. That judgment, you must go and read it, Tau. It says here that it says on paragraph 33, it says that the only object of this exercise was to plunder the resources of the allegedly insolvent fund. And the people it's pointing at are the very same lawyers that today are complaining. Okay? Section 34 says, paragraph 34 says the fund's legal representatives were complicit in operating this scam, as were those of the plaintiff.
Right.
So how do you listen to these people when you have read this?
Yeah, but they're saying you're taking one judgment and you're painting all of them with the same brush. I'm not saying all of them are like that.
It is one amongst others. By the way, here is the thing that is sitting in front of us. By the way, it is scathing on all of us.
Yes.
All of us were scathed in this judgment.
Right.
Because the fund, it says on paragraph 38, it says, 39, it says, the fund's approach to litigation constitutes a serious dereliction of duties to the road accident victim, the public, and the courts.
Right.
At that point, 38 says nothing has changed in the fund's approach to dealing with claims submitted by victims. We go there, we change these things. And of course, in the past 3 years, they've lost close to about 20 billion of money they were making by delaying these things. She's not telling you that there is a backlog that we found of about 300,000 claims. How do they come? They bring empty claims to RAF. Empty. That's why we got with that minimum requirement. The minimum requirements were as a result of the rationale that we found that more than 90% at the time of all claims that were in the backlog did not have any documents to make an offer on. Why doesn't she tell you that they don't actually, what they are fighting with is when we say to them, bring your claim with all the facts so that we can take a decision.
All right.
In 120 days.
So let's talk about that 180 days target. Are you still meeting that? If you're saying you're
120 days. Yes, 120.
Yeah. When you're saying you're performing at 90%.
Absolutely.
Are you making payments to the claimants in that space of time?
You are going to struggle in their letter to find where they are saying we are not paying claimants. Because over the years we have increased the amount of money we are paying to claimants. We have taken away from the lawyers. We are now paying claimants with that money. That's what they are worried about. Now, the reality is this. When they give you an empty claim tab, within 60 days, you must either object or it becomes valid in all respects in law, in terms of section 24.5. Right. They were using this loophole. We then say, but when you say we must assess this as a claim, when you have not given us all the requirements, how do we do that? And that's why we went, and this is a regulation. The regulation came that says minimum requirements. And here's the other issue. All these matters are sitting in front of the court. In law, there's a thing called less pendent. Now, the question is, officers of the court that come out with matters that are less pendent and want to discuss them, what is it they're trying to achieve by doing that? Yeah. They are not allowed. It's unethical.
So
it's against their own code.
Talk to me then about this idea of the panel being cancelled. What's the rationale there? And are you still standing by that decision? Because it is said that now you've got backlogs from here to Timbuktu in terms of capacity, because the people now are in fact, the fund is now no longer represented in some instances where a large number of the cases, judgments is passed without having representation for the fund.
No, the backlog has been reduced actually for the first time. That's not true. Our RNYP, which has requested but not yet paid, has come less than 10 billion. When we arrived, we were sitting at 19 billion. Meaning we had settled claims, but we don't have the money to pay it for 19 billion. Now we are less than 10 billion. That must tell you that we are doing something. But let me read this for you in this Ketsekele judgment. It says, a depressing feature of all the aforementioned judgment is that the instance examples of cases in which the fund must have incurred substantial legal expenses in taking to trial or on appeal claims which it has no basis to responsibly contest. Meaning, we just went in front of the court and then we defended matters that are not supposed to be defended. We don't have a defense. We go there for what is called tactical pleading. We've been accused by the courts for tactical pleading and using litigation as a cash flow management tool. We have stopped doing that. We have hired people that do that. We have got block settlements. What we do, we say, here are the matters. Bring your matters that are ready to be settled. We settle those matters without actually going to court. We have done it throughout the years.
So they're saying that's not what you're doing. They're saying instead of settling, you're actually taking these matters on review. So you're spending more money on litigation at this particular point.
Yeah, that's not true because the litigation cost will show that is in it. There were 10.6 billion. We are sitting closer to 3 billion, less than 3 billion. So what is it we are doing? That's what I'm saying. They have lost that money. It used to go to them. It's no longer going to them. They want us to just give them money. It used to take 8 years to settle a claim that RAF. They actually lost the claim closer to the 3 years. And then they take 5 years trying to put the matter on the court roll.
Yeah.
Now, we have changed that. It was 8 years. As I'm telling you now, 50% of all the claims that we have are done within a year.
Yeah.
Coming from what? 4 years.
What's the number of claims where right now you're currently applying to have judgments overturned?
Judgments overturned, which ones? Because the default judgment would not do that in cases like that, because the default judgment is simply that we do not have any defense that we had. Unless we see that this did not have merit, then we will call for a rescission. So there's no truth to that. That's what I'm saying. When you look at the numbers level lighter. I'm saying to you, when we arrived, 10.6 billion was spent. By the way, you must go and look at a study that was done by Professor Henny Klopper in 2019 that said, out of that 10.6 billion, 99.6% of all those matters were settled on the doorstep of the court. Now, why do you settle matters on the doorstep of the court?
The issue is that as they are settled out of court already, resources have been spent in trying to put those cases together. Enormous costs of litigation are already incurred. And then you get to the doorstep of the court and you say, okay, we settle.
But that's what we are avoiding now. That's what we are avoiding. And that's why we are saying our model is to settle these matters before they go to court. Now remember, a lawyer only makes money when they go to court. Where would they make money if they are not in court? Which legal costs are those? Now you can imagine. I mean, they will want to turn this thing. It's not true. The lawyer can only make money if the matter goes to court. What else would he be doing? Because filling a form and then attaching stuff cannot take you that long. Where would those costs come from? What is called pleadings. And those pleadings were us asking for documents that they had not given at the beginning of the claim. And that's why now we have done the pre-assessment to assess these things within 60 days so that we can object. And guess what they do? When we object, they try to go for summons, which they are not allowed to.
The Road Accident Fund CEO, Collin Letsoalo, responding to a memorandum that has been written by 10 organizations of lawyers that are calling on the Minister of Transport to fire him, essentially, and the board at RAF. And he's come on to say, well, it's precisely because of the work that he's been doing, particularly in reducing the costs to the fund, and the lawyers are particularly unhappy about that. Let's come back to this then. One of the issues that has been raised about how the organization is functioning is that, one, Scopa says you have put in place a financial management system that is inconsistent with the law. And this has been flagged by the Auditor General. At some point, you were going to challenge this in court. Apparently, you were given an instruction by the Minister of Transport to say, no, don't challenge this thing. But apparently around the fact is that there is 80 billion rands that is not explained in the books when they look at this issue. Just address that for us.
No, there's no truth to that, Tabo. Once again, I think the difficulty with this thing is trying to explain an accounting policy to people that may well not understand accounting very well. As we say, these matters are least pending, meaning we have submitted this matter on the 3rd and the 4th of October will be in front of the North Gauteng High Court. The long and short of it is that we used an accounting policy that is for social benefits like we are. And the argument that people would have is that we are an insurer. We are no insurance. We don't have any policies. The accounting policies that people want us to use is the one that accounts for insurance policies. We don't have anything like that at the Road Accident Fund. And therefore, there was a position that was taken, and we stand by that position. And we have not withdrawn any litigation, by the way, because we think that in terms of Section 34 of the Constitution, we are allowed to approach the court if we think a matter can be resolved by application of law. And I think once that comes back, we will have to look at it, and people must give us time to be able to deal with these issues. And we keep on saying we are very confident about what we have done so far. And there's nothing we are hiding, by the way. All these things were discussed with all people involved, and that will be ventilated in the courts under oath.
All right. Let's look at the HR matters. Are you suspending people willy-nilly there? Because it seems they're saying you are suspending people without following due process.
Imagine this. Lawyers now telling us how to run HR. It must tell you something. We are dealing with syndicates here. Syndicates that includes them and people internally within the Road Accident Fund. That's a known fact. And therefore, when you deal with that, you are not surprised why people then make noise about suspensions. I mean, suspensions are done in terms of the law, the labor laws of this country. Yeah. And you do a suspension on those bases. And I mean, why would lawyers complain about suspensions? We are told in Parliament every time that when you go there, we need consequence management. And of course, consequence must befall people that are defrauding the RAF. Yeah. Including this very same lawyer. We had people...
is that not adding stress to the organization where you have, for example, somebody who would be handling more claims than they ought to? So one person handling 3,000 claims, they don't see some of them until they actually have to appear before the court or something of that nature.
So Thabo, what are you saying? You must say I must keep thieves because if they leave and they are suspended, then... there is a capacity problem. Is that what you are saying?
No, I'm saying address the capacity problem. Yes, you can put consequence management, but it shouldn't then affect the functioning of the organization.
No, it's not. It's not. As I'm saying, we have got capacity that we are bringing about by systems that we have put in place. So the reality is this. We have reduced the number of inflowing claims by 97%. What I'm saying to you, Thabo, is that they used to bring incomplete forms, things, claims that are not complete. Now, we have put a pre-assessment in place, and only 3% of those go through. That must tell you that they were drowning the system to make sure that they use this 24/5, so that all these claims are valid in all respects in law. It's no longer happening.
So is that what they mean when they say you are preventing victims from lodging claims?
Absolutely. There's no such a thing. Let me tell you what happens. A victim calls us and says, I have lost a claim. They say it's with you. And we say, yeah, it's with us, but it is missing this document. He says, but I gave them on the first day to the lawyer. What they used to do is deliver these documents empty and then use pleadings to then bring in these documents and drip feed us for the next 4 years. It's no longer happening at the Road Accident Fund.
Now, talk to me.
So that's what they are unhappy about.
Yeah, about this issue of you are not engaging with, for example, a claim that is prescribed and right up until the last minute.
No, but if it is prescribed, yes, prescribed. I mean, you don't allow it to prescribe because prescription means 3 years, and if you don't bring someone within a certain period, of course it will prescribe. So those are the issues. So it's not something that RAF would do. And that's why we have stopped this direct claims. These guys have been fighting a thing called the Road Accident Benefit Scheme. The lawyers have made sure, if you go and read 19C, Roman figure 1 and Roman figure 2 of the RAF Act, you see that they are the only people that can actually bring claims in the Road Accident Fund. They wrote this into the Act. So when we deal with these matters, of course they are going to be upset. And that's why I'm saying, Tab, we have duplicate payment, more than $1 billion. 102 law firms were not paying us. We reported them to the LPC. Nothing was done. There is a case now with one of the law firms here in Cape Town there, where this person has just been a recalcitrant lawyer doing things that are not according to what lawyers must do, misappropriating funds and doing all funny things that are misconduct. 3 years, nothing has happened to that person. We go to court, we say, suspend this person, the LPC is defending that person. It's a very interesting thing that the Legal Practice Council, which is supposed to be the regulator, also adds its voice on these matters. When they are supposed to be acting in the public interest, they are protecting lawyers. So it's because lawyers are having a thing called self-regulation. They are regulating themselves.
Yeah.
And of course they are going to make noise. We expected this. There's nothing about it that we did not expect. As I say, the applications that were open for the CEO, they were all there. They contested. They were beaten. They tried to go to court. They don't win now. They are trying to create a so-called crisis that is not there.
So
that is not correct. And I'm saying,
I don't know if it's in this memorandum, but there is a claim, certainly I'm seeing in some of the reporting, that you are dealing with those law firms that are involved in that application to overturn your appointment by not processing their claims.
No, that's not true. I don't do that. That would be unlawful. But that's why I'm saying one of them is an attorney called Kabelo Malao of Malao Incorporated. That's the guy that we're trying to strap off. Why? Because this guy is doing things that we are putting it in front of the court. Because we are saying all the time people make this noise. Even this noise they're making, they won't put it under oath. Let them bring it under oath. Because you see, we bring everything under oath. All these things we are saying, we have performed in this way, they are all under oath. And we are saying they must bring all these things under oath. Because they can't create a situation where lawyers are just upset by the fact that over the period, the RAF is now getting its efficiencies in place and they are no longer making money off it. They must say that.
All right, Mr. Letsoalo, I'm going to invite you back into the studio, and I want you to have a little bit more time for this conversation. But let's leave it there for tonight, and thank you very much for coming on.
I would love that so much. Thank you so much.
Fantastic. That's CEO of the Road Accidents Fund there, Collin Letsoalo, responding to that memorandum that was issued by those 10 organizations. It's still ongoing, and certainly calling for an engagement with the minister as well on this particular score.